Hey, did you know that in Florida, refusing a breath test during a DUI stop can now land you in jail, even if it's your first time? That's right. A major change in Florida law has turned what used to be just a license issue into a criminal charge. If you drive in Florida, this is something you absolutely need to understand. My name is Dion West. I'm the managing attorney at Jericho7law.com. And today I'm breaking down Florida's new DUI refusal law and what it means for drivers. Let's start with the basics. Under Florida implied consent law, anyone who drives in the state automatically agrees to submit to a lawful breath, blood, or urine test if they are arrested for DUI. Before the law changed, a first refusal usually just meant administrative penalties like losing your license for 1 year, but it was not a separate criminal charge. However, that changed with Trenton law, which went into effect October 1st, 2025. Now, if you refuse a breath or urine test after a lawful DUI arrest, you can be charged with a second-degree misdemeanor, even if it's your first refusal. That means you could face up to 60 days in jail, up to 6 months of probation, a fine up to $500, and a 1-year driver license suspension. And remember, this refusal charge can be in addition to the DUI charge itself. If someone refuses testing a second time or more, the penalties are even more serious. A second refusal is a first-degree misdemeanor, which can carry up to 1 year in jail, up to $1,000 in fines, and an 18-month license suspension. Another important point, law enforcement officers must now clearly warn drivers refusing a test can result in criminal prosecution, not just a license suspension. But here's something many people don't realize. A refusal case can still be challenged in court. Under Florida law, several defenses may apply depending on the facts of the case. For example, a defense attorney may challenge whether the traffic stop itself was lawful. If law enforcement did not have reasonable suspicion to stop the vehicle, evidence from that stop could potentially be suppressed. Another defense involves whether the officer had probable cause for DUI arrest before requesting that criminal test. Attorneys often examine whether the officers properly read the implied consent warning, because if that warning wasn't incomplete or inaccurate, it may affect the validity of the refusal allegation itself. In some cases, what officers claim what was a refusal may actually be just confusion, medical issues, language barriers, or unclear communication, which can be some critical issues in court. Body camera footage, dash cam video, and witness testimony can also play a major role in challenging a refusal charge. Listen, the key takeaway is this. A DUI refusal charge is serious, but is not automatically a conviction.